Thank you. Good morning. I start every one of these talks by saying nobody ever goes to law school to be a ditch lawyer. That was not my ambition as I was growing up. In 1978, I was the newest attorney in our firm. Our firm's located in St. Cloud. It's the same firm. I'm just, I think, finishing about the 35th year. And in 1978, as the newest attorney in the firm, we had two ditch files in the firm, Stearns County Ditch number 7 and Stearns County Ditch number 32. Since I was the newest and probably looked like incapable of doing corporate law or something that actually takes some ability, they were put on my desk. As it turns out, it's the best thing that ever happened for me. I do basically only drainage law and wetland law across the state of Minnesota. I am basically an attorney with a truck driver with a sport coat. I will be, one day I am on retainer to probably 40 or 50 different watersheds and counties. One day I'll be in Roseau, the next day, and I'm leaving from here to go to Austin on a swamp buster hearing. I'll be in Redwood Falls tomorrow. The next day I'll be someplace. And Owatonna next week, and Litchfield, and just wherever it happens to be, which I enjoy because I can't think of anything worse than sitting and reading corporate documents all day chained to a desk. And as I do this work for the last 35 years, and it's always been work that I've had plenty of work, but for some reasons I'll talk about and most of you know about, I've been busier the last 24 months than the 33 years total before that, and I don't see any change in that happening in the near future. And the reasons for that is that, and again, I'm preaching to the choir here, you know the reasons, but we have a perfect storm. For my business, right now, I've got 7, and probably more than that, things that have all come together to cause a need. Again, I'll be talking mainly from, as Sean said, the economic, where agriculture is going when it comes to drainage. But we obviously have high land values. And I don't know where it's going to end, but as I talk to people that deal with it a lot more than me, with money markets paying 0%, people having some ability to put money somewhere, land is still a place that it is being placed. You're seeing that landowners are saying, no, I need to get a return, as good a return as possible on every acre, and I deal only with agricultural people. They're my friends, but it's fun to deal with them because 4 years ago, if you'd have said 720 corn, they'd have done handsprings. Now they're saying, I don't want to sell. That's not enough money. I always get a kick out of that at what level are you willing to sell? The main one, though, we have old, undersized systems. I'll give you a real quick history of drainage in Minnesota. All your large drainage systems in Minnesota were put in between, not all, but most of them were put in between 1903 and 1918. If I go to Waseca and go to Joyce's office, the auditor's office, and say, show me your county ditch files, they will show that Waseca County Ditch number 1, I don't even know where it is or what that is, was probably built between 1903 and 1918. Water at that time was viewed as the enemy. All the court cases all said water was the enemy. There was no economic future for agriculture in Minnesota unless you drained. And at that time, there was even health reasons that they said we had to get, for health reasons, we had to do drainage. So both in county ditch systems, which I'll explain, and private systems, when you look at their income per year of agriculture at that time and the amount they were putting into drainage, the capitalization costs, it was astronomical. At that time, they were hand digging in the tile. That's why there's whiskey bottles on the bottom of all these tile trenches. Can you imagine getting up in the morning and say, I've got to go across the 80, it's a 9-foot cut, which means, you know, they would, I just can't imagine. They didn't need athletic clubs in 1910. They were plenty of things to do. And so those systems, though, were put in at that time to simply dry down pasture. They were not thinking, obviously, pattern tiling. They were just trying to get some areas for their pasture land, a little bit of crop land, but mainly just to get some water off some land so they could actually have any future in agriculture. In northern Minnesota, it was for timber. We have a huge number of ditches that were put in at that time in northern Minnesota for timber and for wood. And so throughout Minnesota, you will see these systems that were put in, and now we've got 1912 systems. We're over 100 years later. They put in a 12-inch tile line, which probably at that time seemed like a pretty nice, well, if I'm hand digging it in, it was a hell of a size tile line, but at that time they were thinking, you know, this is a significant piece of work that we're doing. We are still using those 12 and 14-inch mains today, 100 years later. Think of anything else on your farm that you're using 100 years later, almost nothing. And those tile lines, if you don't touch them, are still, you know, somewhat working. If you actually send, we have cameras, we send up the tile lines, and they're all offset, they're cracked, those old tile lines, but they're still fundamentally, obviously, draining water from your property. But when you try and hook up your pattern tile and touch them, that's like tissue paper. People tell me, I obviously don't farm. You'll see, all of you that have seen the head pressure blow those intakes right out of the ground, or water come out of the intakes of the tile. So we've got those kind of systems in place with 2013 agriculture, looking ahead to 50, 100 years more of farming that same land. It's not going to be sold to apartment buildings and Walmarts. It's going to be farmed for the next 100 years. So are we going to use 1913 systems? Those systems are all collapsing. They need to be replaced. Are we going to put in a 12-inch main when everybody's pattern tiling into it? Again, purely economics, the answer is obviously no, we're not going to replace it with a 12-inch main. We're going to plan for today's agriculture, and assuming the tile we're putting in now is going to be used 50 years at least from now, where do we see agriculture going? So anyway, kind of jumped around there. 1918, then from 1918 to the 1950s, almost zero drainage. We had dry conditions in the 30s, Depression, World War II, almost no drainage going on. Then in the 1950s, we had a huge push for drainage again, and it's very obvious why. Many of you are my age or older and remember when Khrushchev came over, the Soviet premier came over and said, "We will bury you in wheat." And U.S. agriculture said, "Like hell you will." And those of you that farm, remember the SCS, the predecessor to the NRCS, you were paid 75% cost share to install drainage. You would have been an un-American farmer in the 1950s not to be installing drainage. And that's always stuck with me, that you have to put things into a historical perspective. I always remember the Red River Valley farmer that came up to me and said, "Kurt, everybody's saying we're doing everything wrong at that time, that we destroyed the world or whatever." And he's saying, told me that story, that we would have not been good agriculture in the 1950s and early 60s unless we were installing drainage. And again, that's why I always get a kick out of everybody, including me, thinks we've got the answer today. Whatever we're doing now is right. I guarantee you 50 years from now, they will look back and say, what the hell were those people thinking with whatever we're doing today? I don't know what it is, but clearly it'll change and things will be different. So as Sean said, will drainage go away? Will improvements go away? Will projects go away for drainage? Absolutely not. They're accelerating. I'm busier than I've ever been, and it will rain again. And when it rains, the drainage inspector in every county or watershed that I work, the phone rings off the hook. My phone rings off the hook because of the first three items. Wet conditions, the last 2 springs have been very wet, and we've had strange years. We all you expected to use your dryers in the fall and never did then after looking at what it was like in the spring. But again, we are going to see those conditions again, and it's so obvious in agriculture now where you see your need. With your yield monitors, you know exactly as you cross an area that needs another stringer of tile exactly where your yield goes down. Again, from purely economics, every study at Iowa State, Ohio State, it's a no-brainer from economic point of view, drainage. You get the best return for your dollar with drainage. It's not even close to anything else. And so again, strictly from an economic and future of economics in agriculture, there's going to be more drainage, and more drainage, installation of more tile. I stopped at Prinsco, which is located in Wilmer. They're up to 8 plants in 10 states. ADS is adding plants. As Sean said, eastern South Dakota is not eastern South Dakota anymore. Eastern South Dakota, for some reasons I'll talk about, they don't have a state wetland law. And a lot of their landowners have opted out of the farm program for Swamp Buster, and so they have no wetland protection, if you want to call it protection, in eastern South Dakota. I agree with what the doctor said. In Minnesota, are we doing more drainage? Absolutely. Are we draining wetlands? In my opinion, no, for a number of reasons I'll talk about. We're draining areas that need more drainage, but generally we are not draining wetlands. If anything, we may be increasing the acreage of wetlands. The big one is fear of future regulation. Again, from a pure, this is where my family makes their money. My kids are going to make money off this land. The concern about future regulation. There's no question that the agencies realize the amount of drainage going on out here. The last 2 falls, I wasn't run off the road in western Minnesota by sugar beet trucks. I was run off the road by tile trucks because they are delivering so much tile. It's being stockpiled because you couldn't get it 2 falls ago, and I don't see that changing. And part of that is because of the concern about what's going to happen in the future. For an example, tile is exempt from the Clean Water Act. The Clean Water Act says if I have a factory and I have a pipe coming out of that factory and it ends up going into waters of the United States, I need to treat that water. It has to meet water quality standards. Agricultural drainage tile is exempt, does not have to meet those standards. And there's an argument whether it's already cleaner because, I'm not going to get into the quality of water coming out of tile, but there's certainly a very good argument that it's way better than coming off surface drainage, especially if you don't have open intakes. But, I'm not the scientist, but that's what I'm being told. But again, if they ever make agricultural tile outlets point source, it's called point source under the Clean Water Act. If that is ever determined to be point source, it'll be a game changer for agriculture in the fact that there will be then and there's no question it'll come. That's not the issue. Will you have water quality monitors at the end of every large drainage system at some point in the future? In my opinion, absolutely. Because everything we've done in drainage up to this point has been quantity of water. Quality of water quantity is still a big issue, but quality of water will be the next big issue, not next, it is a big issue, and how we regulate that in the future. So again, from a pure economic, this is where my family's financial future is. Am I going to stay right now with a 1912 system, or am I going to improve that system while I still can so that my family, I don't mean to be preachy about it, but again, from that point of view, so that my family has economic future in agriculture, I'd say the evidence is obvious that that's what's going on. There's been a reduction, if not a reduction, in conservation money. When corn was $3 a bushel or whatever, and you were looking at marginal land that flooded, that had stress 2 out of 5 years, and you looked at the conservation program versus what you were getting by putting it into crops, sometimes it was relatively close, and for other reasons than pure money, you put it into conservation. But even from an economic point of view, a lot of times you said, I'm going to put this into a conservation program. Well, now with the commodity prices, and I talk to the agencies all the time, and I'm a supporter of conservation programs. I'm not bad-mouthing them whatsoever. But again, from a pure economic point of view, it's not even close between putting tile in and row cropping it versus putting it into a conservation program. And then the last one, and this one, again, all my clients are in agriculture. I listened to 31 out of the 35 years of how bad agriculture was. I got my 1/4 inch rain an hour late today instead of the hour before I should have had it. And I kid them because they are good friends. But when my clients come in now and they start saying something about how bad agriculture, I go, Joe, don't even go there. If you haven't made money in farming the last 3 years, you should go to bartending school. Because I don't know the first thing about farming other than what I can read, what other people have told me, but I've had more and more and more landowners say, you know, Kurt, I made more money the last 3 years than 30 years total. And for some of you that are kind of more my age or even older, you farmed in the early 80s. This is me preachy again. Some of the guys that have only farmed the last 5 years think this is printing money. And some of the older guys are saying, hey, you wait, we'll see what happens with the dips here. And sometimes you need a dip just to bring people back to reality. But right now, you are seeing that farmers have money. They didn't wake up yesterday and say, Waseca County ditch number 1, if it happens to be a tile system, is undersized and old. They didn't come up with that yesterday. Most of the projects I start, they say, I wish the dads in the 1970s met on this to do an improvement project, and because of economics or whatever reason it didn't go, I wish they'd have got it done. It was before Swamp Buster, it was before Waseca, it was before all the regulations. We could have had that project done at 1/10 the cost, but for some reasons I'll talk about later, they didn't get done. But those are all coming back to get worked on. Example, Martin County. Martin County is Fairmont, Minnesota. Fairmont has, just in county ditch systems, has 240 ditch systems. Most of them are tile. Most of them were put in 100 years ago. I'll never have to do divorce law. That's my goal in life. Other than my own, if I ever get divorced, maybe my own divorce, but I don't plan on that. But my goal was always never to have to do divorce law. And just in Martin County alone, we've probably done 4 improvements. That means I've got potentially over 200 improvement projects just in that. That's just that county. Jackson County, Nobles County, Faribault County, Blue Earth, I mean, all the counties that I'm involved in have unlimited potential improvement projects, and that's just the county systems. I'm not talking the millions or hundreds of thousands of miles of private systems that Grandpa's put in that were 12-inch private systems that now need to be improved. And obviously the tax policy. Again, agriculture, you know, it's got good and bad, but from a pure tax policy has, you know, you're either going to pay taxes or you're going to buy tile or you're going to, I spoke in Hancock, Minnesota about a month ago, and it was an ag store, ag place. I pulled in and there was probably 80 landowners there and probably 60 pickups. I thought I was in a new pickup lot. I have never seen. What happened to your old Ford sticks? I mean, these were Escalades. I thought, what part of the farm do you drive that on? But it was just new truck after new truck, and that's where agriculture is right now. So anyway, that's kind of what I see as the driving force of what's going on. Then I want to talk about just general common drainage law in Minnesota. I get calls every day. My neighbor installed a pump. Isn't that illegal? My neighbor's lowered his waterway. Isn't that illegal? My neighbor installed a tile line and has a forced outlet on the property line. Isn't that illegal? The good news is I bill by the hour, and the answer is never yes or no. You can't, I couldn't make much money with yes, that's illegal, or no, that, you know. Even I can't stretch that longer than a few minutes. So, and that's because Minnesota is what's called a reasonable use test state. That means you can drain your property as long as you don't unreasonably harm your neighbor, and you can block drainage as long as you don't unreasonably harm your neighbor. And from a lawyer's point of view, there's no better word than what's reasonable or unreasonable. That's a battle of the experts. When people call me with that question, it took me 25 years probably to learn this. As soon as they call me and say, my neighbor's doing such and such, isn't that illegal? My first question, very first question is, is this a real drainage problem, or did something happen at a wedding 50 years ago? And your grandpa hated the neighbor, your dad hated the neighbor, you don't know why you hate the neighbor, but grandpa said you're supposed to hate the neighbor. And for the years that I did, the first 25 years I did this, my projects weren't based on whether it was economically feasible or all those type of things. It was which neighbors wanted what. If one guy said it was sunny out, the other guy says it's raining out. They just couldn't get along. Well, that's changed for a number of reasons. We have a lot of absentee landowners. We have a lot of renters. You don't go to the same church. You don't see each other in school all the time. He didn't beat you out for the basketball team or whatever the long-term reasons your family didn't get along. And so now we have those situations. When people call me, I say, fine, if your neighbor did this, sounds like you may have a claim under the reasonable use test, but don't spend a dime with me. Go hire an engineer, Chuck, or a hydrologist, or, you know, there's several in the state that I would recommend that are very good. If they back you up, then come and see me again. Two things happen. Either if they don't spend the money with the engineer, it means they just wanted to use me as a sword against their neighbor. They had no intention of solving the problem. And then secondly, if the engineer backs it up, then we may potentially have a case. The last one I tried was in McLeod County. It was between two brothers. You know, the old saying, whiskey's for drinking, water's for fighting. And these two brothers both didn't like each other and had some disputes over the property line and water. And they spent way more than what was involved in the case, simply because it was disliked more than the water issue. Fortunately, I won the case because I had the least crazy brother. So sometimes, you know, you hope he's not here because he's not crazy. I use that story, but he's actually not. But they were willing to spend whatever it took. And I'm kind of belaboring that, but these are some of the issues, and everything I'm talking about is in those packets I handed out so that it's in there. One thing I want to talk about, though, when it comes to reasonable use, this is a pay me now or pay me later. If you've got 7 private landowners on a system that was put in 1913 by your grandpas or great-grandpas, and it was done on a handshake in 1913, and you don't have a drainage and maintenance agreement, you will either pay me now to do the drainage and maintenance agreement, or you will pay me or somebody in the future when there gets to be a dispute on maintaining that tile line or the ditch. Because if it crosses 7 people, and you don't have a drainage and maintenance easement that's recorded on the abstract, if that 4th guy down says, no, I'm not going to let you fix that tile, you have absolutely no right to go on that landowner's property and fix that tile. Now, back to the reasonable use test, he can't purposely break it. He can't, I mean, I've had every case of huge hay bales on the fence line to building berms. They can't do that type of thing. But if the ditch fills in naturally and you don't have a drainage and maintenance agreement, and with the amount of money, if I was farming and putting in $273,000 worth of pattern tile line and a pattern tile, and I didn't have a guaranteed outlet, I'd be very nervous about that, because it used to be farmer, 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 farmer. Now it's farmer, hobby farm, wildlife area, DNR property, farmer, 1031 exchange. They don't all have the same interest. So we're doing more, and it's not that complicated. It's not brain surgery. We have boilerplate agreements. If you come in and you know what land it crosses, what triggers a repair, who's going to pay what percentage of the cost, it's very easy for us to put it into an agreement, get it on the abstract. Then you don't have to worry if the 5th guy down sells to the DNR, which he has every right to do. I'm not a proponent. You should be able to sell your property to whoever, but you want to make sure if you're upstream that you have the ability to maintain that, especially if it's an outlet for your pattern tile that's the economic lifeblood of your farms. There's 2 types of drainage systems in Minnesota. We have private drainage systems, and by systems I'm talking ditch, open tile, or tile, ditch, whatever, pumps, all of those. When I go from here, I represent Turtle Creek Watershed, which is in Hollandale, Minnesota, north of Albert Lea. That, people from Holland settled there, you know exactly why. It was nothing but sloughs. They don't call Maple Island, which is a little town there, Maple Island. It's Maple Island because that's what it is. It was surrounded. So they came over in the early 1900s because they knew how to handle that and turned it into a vegetable farming area at that time. But in that area, Ditch 24 is 50 feet deep and 80 feet wide. It's bigger than most rivers are. Everybody pumps over the berm into the ditches throughout that entire system. So some parts of the state I go and they say pumps, you can't pump. Well, some parts rely on pump. Minnesota's, kind of jumping around here, Minnesota's a strange state. I represent Lake of the Woods County, Roseau County, Marshall County. When I go up there and they say preserve, and the law says preserve wetlands, up there they go, what do you mean preserve wetlands? We don't have any upland up there. You know, it's all wetland up here. Then I go to Rock and Lincoln County. Rock and Lincoln County has 2 wetlands. I think they both were created when somebody spit. I mean, there's just, they've drained everything pretty much there. And not wrong or right, I'm just saying that's what's happened in that part. So we have some wetland laws that apply across the state of Minnesota, and Minnesota's totally different. When you're in Roseau or Baudette, it's nothing like being in Ivanhoe and wherever in the southwest part of the state. So we've got all these private systems. Then we have, and what I deal a lot with besides private systems, are what are called county ditch systems. We have a drainage code in Minnesota, 103E. It's been the drainage code in Minnesota for over 100 years. We've done some recodification. Several people, as I look around the meeting here, are going to be at the meeting Friday. We have the legislature mandated a drainage work group, and we've been making changes to the statute as we go. But very honestly, and I think everybody, those would all agree that are in the room, we're making changes that are administrative, that change some things, but not the basic skeleton of drainage law in Minnesota. It was so important 100 years ago, it's important now. There's going to be issues in the future, but we are working by consensus to make changes that make sense. But those county systems, so when I talk Waseca County Ditch Number 1, Waseca County Ditch Number 1 is not owned by Waseca County. Most of you know this, but every county ditch system is owned by the people that were assessed to build that system in 1913. The county, whether it's the county board, joint board, watershed district, who's ever the drainage authority, they act as the banker and the referee. They do not own that system. They're simply there to make sure that 103E is being followed as far as the hearings, petitions, those type of things. So I always want to leave the meeting with people so that when you, because county boards still get a call, you know, County Ditch 2 is blocked, get it fixed. Well, it's your ditch. If you didn't ever tell us that it needed fixing, we have a duty to repair it. So we need to repair those systems, but if that 12-inch tile needs to go to a 24-inch tile, we as the drainage authority can't do that. It has to come from a petition from the landowners. We can't initiate that under our own motion for some reasons, under the statute for some reasons I'll talk about. So, but those are some of the things that are different between public and private drainage systems. Are public drainage systems getting more popular? Absolutely, no question. Deer Creek, I'm talking in the Hollandale area, Deer Creek was a private lateral that ran into Ditch 24. Deer Creek had a drainage and maintenance agreement. It covered miles and miles, very well done decades ago. But those landowners came in and said, look, we don't even know who owns the land anymore. We don't know who to collect from. We don't even know, we just can't, it's just too big to operate as a private system. They petitioned to make it a lateral to Ditch 24. Now Ditch 24, we have a drainage inspector. I won't bore you with everything, but now those people don't have to worry about can that system be maintained. Secondly, many of the wetland regulations have exemptions for public or county ditch systems. So there's reasons why more and more private systems are being converted to 103E systems, just because there's better records, better ability to repair, better cut sheets so that you know how deep the ditch was, just a whole different number of reasons why we're going that way. And I think we will go that way more and more into the future. It's amazing, I've been doing this 35 years. When I used to go out and visit my clients and we'd go out to the end of their driveway, they could tell you who owned every 40, who was farming every 40, all around them. Just the other day, we came out of a guy's driveway right across the road. He said, I have no idea who owns that. I have no idea who's cropping that. He sees them 2-3 times a year. Some big tractors pull in. That's the only time he sees them. He's heard they're from X place 40 miles away or whatever it is. So that's part of the reason that we're trying to get, or the landowners are saying, hey, this private situation needs to be converted. All right, when I do any type of large wetland, large county or private system, I obviously need to deal with the wetland issues. And very quickly I'll go through these without trying to bore you or cover everything about them. But when I deal with the wetland agencies, I hold what I call an I don't care meeting. And it comes from the movie The Fugitive about Ketchum, who murdered his wife, and Tommy Lee Jones says, I don't care if you did it or not. My job is to catch you. I don't care. That's my attitude toward the agencies. The agencies are friends of mine. They have a job to do. I always preach that if it's the DNR local hydrologist or the DC for NRCS, they didn't write that law. Their job is simply to implement it. I get sometimes they never do when I'm there. I have clients where the agency said, your client was screaming every 4-letter word at me. Somehow when I show up, I've also had the agents, both sides say that it can get very heated out on the site. So when it comes to a client calling me, they always say, somebody was just out here, and they always say it's the DNR. And I always have to say, what color truck was it? What were they wearing? What did their name? Because it's always the DNR, and it's almost never the DNR. Because the DNR is a very small player when it comes to ag drainage. And I'll go through these real quickly. The DNR, which is state, I keep 2 of these are state and 2 of these are federal. DNR, which is state, only has jurisdiction over public or protected wetlands and watercourses. And those, in 1981, I was practicing, those protected wetlands are type 3, 4, and 5 wetlands of over 10 acres. They're wetlands that even Kurt DETER would say, that's gotta be a wetland. I mean, sometimes type 3s are close, but when you're into a type 4 or type 5, you're talking obviously a wetland. So the DNR, they inventoried them in 1981, and it also covers watercourses that carried more than 5 CFS. And so if I hold the meeting with the 4 agencies and you're the DNR person and I'm doing an improvement project and I look at you, do we have any public waters here? They can look at the public water inventory map that's on file with the auditor's office, although they were filed 30 years ago almost. They never can find them in the, because we've got different auditors, but the area hydrologist has those maps and they'll say, yes, you got 67W, they'll have a number on them. Then we have to deal with that issue. But if there's no protected waters that my project's going to affect, I say to the DNR, thanks for coming, and if they say, no, Kurt, I want to tell you what I think about this project. I don't care. I mean, I say that without being sarcastic. I'll have a beer with you afterwards and talk about, what you think about the project. But from a strictly jurisdictional and whether I need a permit or whatever, if I don't need it from them, then I go to the next agency. The next one, and the big one for farmers, is NRCS and Swamp Buster. All these other agencies, they can do cease and desist, they can do restoration orders. You all know Swamp Buster affects your pocketbook. You do not want to get kicked out of the farm program. Right now you don't need LDP payments, so right now there's kind of a thought, should I be in the farm? But with the way things go long term, if you do things now, get out of the farm program, drain some, even if you could, drain some wetlands. If you ever want to get back into the program, you're going to have to get back in compliance. So with the NRCS, the NRCS, those of you that know Swamp Buster, after December 23rd, 1985, you cannot convert wetlands and and get your farm program payments. From 85 to 91, it took 2 triggering devices. If you drained it and planted a commodity crop, if you just drained it, that wasn't a violation, but if you planted a commodity crop, that triggered it. From 91 till now, the mere act of converting a wetland gets you kicked out of the farm program. And I'm going to one in Austin now. It's an interesting situation because the work was supposedly done in 1995. The guy bought the property in 94. He was an elk farmer. He went to the office that he thought he was supposed to go to. He didn't get farm program payments in 95. In 2012, they found a supposed violation from 1995. He wasn't getting farm program payments. So the issue is, well, when he came in the next year to get farm program payments, somebody should have told him, and he had no history of knowing anything about the farm program, should have had him fill out a 1026. Have you done any drainage? Because they actually sent out at that time, there weren't these privacy rules, and the Waseca people in the NRCS office could go down the hall and work together. One of the worst things that's happened, in my opinion, for wetlands are these privacy rules. I can't go in, if I want to look at your property to buy, I can't go in and say, let me look at the wetland map for your farm because of the privacy issues that came out of this publication of farm subsidy payments. Now they've swung it so far that even the other agencies can't get information from NRCS unless you sign an authorization. So anyway, make a long story short, NRCS, no project do I want to get any landowner. This is not a permit. If you don't want to be in the farm program, you don't have to comply with Swamp Buster. But people want to comply with Swamp Buster. The issue is you never know if the map that you have, if you can rely on that. Don Ballone's, I think, a friend of mine, the state conservationist. All of you that farm know that you got a map in 88, you got a map in 90, whatever years you have map, and you thought, well, this is the one doesn't show any wetlands on this. Each time you do a 1026, and if you do a 1026 now, they're saying this is the last one. If you do this one, this is a certified one. I tell them like hell it is. You'll switch the map. Excuse me, I keep using that word. I don't mean to, but that's kind of the way I talk to people sometimes. But so it's very difficult for Swamp Buster to know. And the W's don't bother any of you. If it's never been cropped, yes, I'd like to crop it with $7 corn, but you can live with that. It's the FWs, the farmed wetlands on your field. FW means that it's got a cropping history and it's got a drainage system in it. You can only repair what's in there. So you got to leave a 1912 size tile in there, even though everybody up above you is draining down and coming out of your intake, and what was a 0.2 FW is now 0.7 or 1.3 FW. And so now they've come up, or they're working on and come up with a farm wetland bank, because you couldn't compete with Walmart for wetland credits. Now if you've got a 0.2, a 0.1, a 0.4 on a field that screws up all your pattern tiling, you can go to a farm wetland bank and buy wetland credits. They can be expensive, but for some landowners, they say those 4 areas have bugged me for 50 years. They're screwing up my pattern tile. I want to buy credits and be able to improve that area. In 1991, so state, federal, 1991, this is state again, the Wetland Conservation Act. The state passed the Wetland Conservation Act. There was, at that time, the belief, well, maybe some people will be not in the farm program. We want to make sure that, I think they called it a safety net or a net that we catch those people too, so they aren't, so you also have the State Wetland Conservation Act. The big change that's happened here from 91 till about, somebody correct me, about 4 or 5 years ago, 4 years ago, if you were in compliance with Swamp Buster, you didn't have to worry about number 3. But that changed because the agencies couldn't get together and come to an agreement. Now I've got several cases where the landowner went in and filled out a 1026 and got permission to do whatever he wanted to do. And all of a sudden the DNR, who's the enforcement officer for Waseca, comes out and gives them a cease and desist. And they say, I've got my 1026. Well, you didn't come and check with the Waseca people, which is usually the SWCD, who's doing it on behalf of the county, who's the local governmental unit. And then finally, the fourth one, the Corps of Engineers. Corps of Engineers, most of us think Corps of Engineers are down in New Orleans someplace dredging the Mississippi River. Under the Clean Water Act, you cannot place fill in wetlands of the United States or waters of the United States. In the 1980s, the Corps was very involved with wetlands. Then they disappeared for 20 years. I never saw the Corps for 20, 25 years. And now in the last 4 or 5 years, the Corps is there. The Corps has jurisdiction if you're going to place fill in navigable waters. And most of us would view navigable waters as meaning navigable waters. Well, through the court cases, navigable waters means anything connected to navigable waters. And then the issue is, what is a discharge? Obviously bringing in fill, because this law started off as an anti-pollution law in Florida when they were filling the swamps. At that time, I don't think there was any thought it would really affect farmland in Minnesota. But the big issue now, and they just came out with a general permit, is tile fill. So first of all, is it waters of the United States? And then is there a discharge? And historically, if we could plow the tile in, the court took that position that that was not a discharge. They've now, and I know the court people, maybe some court people in here, good people, but several of them didn't know tile from bathroom tile. I mean, they, in my, you know, and I think some of them would be the first to admit it. They were working on some rules. They actually went out, Tim was telling me, and went out and did some field look to see what was actually, how tile is installed, which I think is good. If you're going to pass regulations on something, you should understand how it's installed and how it's being used. So, oops. All right, giving me the hook? All right, good. I will, I think that'd be a good place to stop, because I could, let me just quickly, who the drainage authority, this is all in your packet. You have county boards, you have joint boards if the system is more than one county. If you're doing a new system or an improvement, it has to go to the watershed district. I think I'll stop there. If any of your questions, there's, like most lawyers, I can talk for days. I apologize. So, but there's a whole system of how you do projects, and there's a petition projects. I've got dozens of petitions for improvements going on in this state right now, and I'm going to see dozens and dozens more. My last comment will be, the issue, as Sean said, is not whether we will have drainage, but how will we do it? Will we do it like we did in 1912, or will we do it with impoundments and retention? Nobody in this room is against impoundments or retention as long as it's on their neighbor's property. So I'll leave you with that we're going to have drainage, just how are we going to do it in the future and what the policy people are going to say. All right. Thank you.